In this lecture, we're going to finish easements and begin on covenants. We'll start with negative easements, then talk about terminating easements, and then proceed to covenants. Negative easements. Negative easements are easements that entitle the dominant owner to prevent the servient owner from performing an act on the servient's land. Again, it is an easement that entitles the dominant owner to prevent the servient owner from performing an act on the servient land. The most common type of negative easement we see nowadays is called a conservation easement. A conservation easement restricts the servient landowner from developing the land or building on it. And it is used to protect open space, wilderness, historical sites. It is typically authorized by legislation, and it is found in almost all jurisdictions. Now let's talk a little bit about terminating easements. There are multiple ways that an easement can be terminated. The first is by prescription. Now, to terminate an easement by prescription, you use essentially the same elements that you would use to acquire a prescriptive easement. So, the servient owner would need to do something to block the use of the easement. And that something, the act that the servient owner does, needs to be open and notorious, adverse and hostile, and continuous for the prescriptive period. If the servient owner meets all these elements, then they have terminated the easement by prescription. So, other methods of termination. One is condemnation. Condemnation is when the government actor goes through a proceeding to take private land for public use. Now, when a condemnation suit is filed by the government to take the land, the government must prove two things. The first thing that they must show is that the taking of the private land is for a public purpose or a public interest. And the second thing that the government must show is that they are paying just compensation to the owner of the land that they are taking, or private property that they are taking. So you may be familiar with eminent domain. Well, eminent domain involves condemnation, right? So, and another way to refer to this is taking, right? Or a taking. A taking is, again, when the government takes private property for a public purpose. And they take under the Fifth Amendment. When they take, they have to show the two things that I mentioned for the condemnation hearing, which is they, one, have to show that they're taking for a public purpose, public interest, and two, that there is just compensation. So all of of these terms are used interchangeably. From my research, I'm currently working on a piece about taking private property. And I have found that the word condemnation is used most often to refer to the hearing, the type of lawsuit that is filed in order to take private property. The act of taking the private property is usually called a taking. And again, we refer to this power as eminent domain. So that's how those concepts align. The reason for the differentiation between a taking and condemnation is an eminent domain. You can think of it this way. So eminent domain has to do with the powers that the government has to take private property for public use. Taking is the actual act of the government entering into the property and taking possession of the property. But for the government to establish title that they own the property, they have to go through condemnation proceedings in most jurisdictions. So that's a way to kind of organize the concepts. So if there is a condemnation of the servient land, and that means the government takes the private property, then that condemnation also terminates the easement. All right. So any condemnation of a servient land terminates the easement. So, as you may remember, we talked about an easement by estoppel, right? Implied easement by estoppel by prior use. Well, you can terminate an easement but with estoppel. So an easement that's terminated by estoppel happens if the servient landowner substantially changes their position in reasonable reliance on the dominant holder's statement that the easement won't be used anymore. Right? So another way to think of it, the dominant easement owner, right? So the dominant owner has done something, has done an act, or made a statement, or that the easement will not be used in the future. And because of that, the servient owner substantially changes their position based on that, on reasonable reliance on that statement. An easement can also be terminated through merger. Merger happens when somebody obtains title to both the servient land and the easement, right? So how would that happen? Let's say that A and B own adjoining lands, and A has an easement over B's land to get to the public road. Well, a couple of years later, A decides to buy B's land from B. When A purchases B's land, they now own the servient land. They also have the easement. And so the easement merges with the ownership of the servient land, and it no longer exists. Well, what does that mean? Why would that matter? Well, if A later decides to sell A's first property, then the easement that encumbered, or the easement no longer exists. So the subsequent owner of A's original property won't be able to use the easement that A had to go over B's land because A's easement terminated when A bought B's land. All right. An easement can also be terminated through misuse. So in some jurisdictions, if the dominant owner seriously misuses the easement may be ended through forfeiture. Now, you're not going to see misuse often. It's not a very common way that easements are terminated, but it is a possibility. Another method for termination is through release. An easement holder, which is, again, the dominant owner, can release the servient estate from their obligations under the easement. Now, in order for a release to be enforceable, it must be in writing, and it must be delivered to the servient owner. That is necessary because it needs to comply with the statute of frauds. So absent following those formalities, a release would not officially terminate the easement. Finally, we can terminate an easement through abandonment. But non-use alone is not sufficient to show abandonment. Next, we're going to discuss a case that involves terminating an easement using abandonment. And this case also revisits the issue of a scope of easement. And that case is Preseault v. U.S. All right, Preseault v. U.S. The facts of this case are pretty complex, so I'm going to simplify them a little bit, or as best as I can. In 1899, there was a right-of-way that was acquired over 3 parcels of land. And that right-of-way eventually was sold to the state of Vermont. The right-of-way was to operate a railroad. And to further that purpose, the original holders installed railroad tracks on the parcels. And from about 1899 until 1970, they ran a railroad. The service stopped in 1970. In 1975, the tracks, the switches, and other equipment for the railroad were removed. And so it was no longer used as a railroad. But when the Preseaults acquired the 3 parcels that this right-of-way was located on, they did enter into an agreement with the state of Vermont to give them permission to cross the right-of-way. So it seems that although the state of Vermont was no longer using it for trains and railroads, they were selling for small nominal fees a license to cross, permissions to cross over this railway. So in 1985, the state leased the right-of-way to the city so that the city could use it for hiking as a public hiking trail. And the public hiking trail opened up in 1986. So the Preseaults brought suit, and they claimed that the purpose of the easement was originally for use as a railroad, and that one, the scope of the easement did not cover residential trails, and two, that the easement that the state had been abandoned. And so because of that, the plaintiffs, the Preseaults, argued that the continued use of their land as a hiking trail was what's called a taking. So I talked a little bit in the last slide about what condemnation is, what takings, what eminent domain is, and so on the facts of this case, they were arguing that so a taking can not only be taking title to the property, but it can also be taking an easement. So they were arguing that they deserve just compensation for the use of the right-of-way as a recreational trail. Okay. So aside from knowing takings for that particular reason, you don't have to know the elements or anything like that for a taking. All right, so the court said that the determinative issues in the case were three. First, there was a question about whether the original transfer was only for an easement or if it was for a fee simple estate. So was the original transfer an easement or a fee simple? The second issue was whether or not the terms of the easement, if it was an easement, were limited to railroad purposes, or if they could be used as public residential trails. Was that within the scope of the purpose of the easement? And the third issue was, even if there was an easement, that easement was broad enough to encompass trails, had those easements expired, or not expired, but had they been terminated because they were abandoned, right? So were they terminated because they were abandoned? So on the first issue of whether or not the original agreement of a right-of-way constituted as an easement versus a fee simple, the court found that it was indeed only an easement and not an fee simple. So the original conveyance was for an easement. On the second issue, the court found that the original purpose of the easement was to be used for transportation of purpose, but that it had to be used for a commercial enterprise engaged in the transportation of purpose. So this is a little bit stickier here than we may have liked, right? So the court could have found that the usage was within the scope because the original purpose was for transportation. And if the court had found and interpreted the scope to be broad enough to include transportation, then arguably, a hiking trail where people could walk would be another mode of transportation, and it would have fallen within the scope. However, that's not what the court found. The court here made a distinction and said that the nature of the usage in the original conveyance was actually for commercial enterprise engaged in transportation, not just recreational transportation. So the court found that the scope of the easement did not include recreational travel. Then the court considered abandonment, and it correctly noted that easements are not abandoned by simple non-use. So simply not using an easement will not cause it to be abandoned. In addition to the non-use, there must be acts by the dominant owner that, quote, conclusively and unequivocally shows their present intent to relinquish the easement. Or alternatively, that there is a purpose inconsistent with the future existence. So let's take a look at the facts of the case and see whether or not we think that the state of Vermont acted in a way that manifested a present intent to relinquish the easement, or in the least, that they engaged in a purpose that was inconsistent with the future existence. So let's look at the facts, let's analyze them both ways, and then we'll come back and talk about specifically what the court said. So the facts that support that the state of Vermont abandoned the easement are, well, first, the state of Vermont removed the railroad equipment, right? That would support the idea that they were acting in a purpose inconsistent with its future existence, right? Because they removed the tracks, switches, and other railroad equipment. Second, the state of Vermont made no effort to restart that line, right? They made no effort to undertake or remove the tracks or any infrastructure that would be ready to kind of return it to service, right? So, those facts support abandonment. Well, what about the facts that are inconsistent with the idea of abandonment? What facts suggest that the state of Vermont did not intend to relinquish their easement? Well, you could argue that the state left some of the infrastructure of the railroad there. They left the bridges and the culverts intact, right? So by leaving it, part of it intact, that suggests that they intended to continue to use it in some way. And the second way that the state of Vermont may have communicated their intent was that they continued to take those nominal fees, those fees for various license or crossing agreements, and they continued to take those. And so that could appear as an indication that they were not planning on abandoning. So what did the court hold? Well, the trial court said that the easement was abandoned in 1975 when the railway removed the tracks and switches, right? But this court said that based on the record of facts in front of them, there wasn't anything that would convince them to overturn the trial court's decision, especially because they didn't find the collection of fees for the crossing agreements as convincing enough evidence to show that there was purpose or intent not to abandon. So the court held, the court found for the plaintiffs, and they found for the plaintiffs for two reasons. They held that the original easement did not contemplate recreational use, and that the easement was abandoned by the railway when the railway removed the tracks. They agreed with the lower court. Well, that's it for easements. So we're going to go ahead and move on to land use restrictions, specifically real covenants. A real covenant is a promise concerning the use of land that benefits and burdens both of the original parties to the promise. And it is a benefit and burden that runs with the land. In other words, it continues on to the successors of the property. The rules for a real covenant are pretty complex, particularly at common law. So, what are they? Well, first of all, there needs to be, at common law, there needed to be all 6 of these elements here. So this, at common law, this bottom box for vertical privity should have said yes. These are all the common law elements over here on the left, this far left corner. For a burden to run, you needed all 6 of these elements at the common law. For the more modern rules, we have gotten rid of the need for vertical privity for the burden to run. For the benefit to run, you only need 3 of the 6 elements. Okay, so what do we mean by burden running or benefit running? Well, when we say something runs with the land, it means it attaches to the land. And here we're saying that for the burden of the covenant to run with the land, then it needs to meet, at common law, 6 elements, a modern rule, 5 elements, and for the benefit to run, 3 elements. All right, so the first element is the statute of frauds. So it needs to comply with the statute of frauds, both a burden and a benefit. And for it to comply with the statute of frauds, it needs to be in writing, signed by the person that it is going to be enforced against. Right. Intent to bind successors. For both of these, the burden and the benefit to run, there needs to be a demonstrated intent that that promise, that benefit and the burden, were to bind successive landowners. Then touch and concern. Touch and concern means that it is directly related to the enjoyment, occupation, or use of the property. So it needs to touch and concern the land. Typically, if it is a restriction on the use of the land, that is considered to touch and concern the land. The next element is notice. Now, it could be one of the 3 different types of notice. Remember, actual notice, record notice. And remember, record notice means that this covenant has been filed with the recorder's office, and so there's record notice. Or inquiry notice. With inquiry notice, just a reminder, that means that had the party done their due diligence and inquired or asked the right questions, they would have easily found the covenant. So any one of these three types of notice would suffice. Now, note that you only need notice for a burden to run, but not for a benefit to run. And that makes sense, right? If a landowner is being burdened, we want them to have notice that they're being burdened. But for them to be benefited, we're not as concerned with whether or not they're on notice, right? It is, we go to buy a property, you want to know if the land is burdened with a covenant. If it ends up having a benefit that you didn't know about, then you'd be fine with that, right? Even if you didn't have notice. So that's how you can remember the difference there. Now let's talk about horizontal and vertical privity. So for a benefit to run, you don't have to worry about horizontal or vertical privity. For horizontal privity, it's saying that the relationship between the original parties to the promise is sufficient, right? So horizontal privity concerns that relationship between the original parties. Now, there's a split in authority on the point of what is sufficient for a finding of horizontal privity. Some jurisdictions are mutual interest jurisdictions. Mutual interest jurisdictions are where the original party has a mutual simultaneous interest in the affected land. Where the original parties have a mutual simultaneous interest in the affected land. What does that mean? Well, it's like a landlord and a tenant, or co-tenants, or owners of land that have an easement and they have a relationship because they have dominant and servient lands. So most states follow this mutual interest requirement, but not all. Some states use a successive interest requirement. So in almost all states that require horizontal privity, this element would be satisfied with a grantor-grantee relationship. That's what successive interest means, that they have a grantor-grantee interest. So most states follow the mutual interest rule, but almost all states follow the successive interest rule. At common law, vertical privity was required. Vertical privity has to do with the original parties to the covenant. And it requires that the successor receive the entire estate that the original party had. it requires that the successor receives the entire estate that the original party had. It's pretty simple. If the conveyance is for anything less than what the original party had, then you will not meet the vertical privity requirement. Most states do not require vertical privity anymore, but it was required at common law. All right, we're going to wrap up this video here and pick up next with Deepwater Brewing v. Fairway.